People can get injured on the railroads in many ways. For passengers who get hurt, it falls within the premises liability aspects of what our firm does. A passenger trips and falls exiting the train or walking down the stairs or walking on the platform. We've seen cases where the train operator closes the door on a passenger and he gets hurt. One of the things that you have to be very careful about, that if you're going to be bringing a case against one of the passenger railroads, you have a limited period of time to put them on notice, and you have a limited time in which to bring a lawsuit. So as a passenger, you need to speak to an expert in the field of passenger law so that you don't blow the statute of limitations or the issue of the notice of claim. The Federal Employers Liability Act, the FELA, was passed early in the 20th century, allows a railroad worker in interstate commerce to bring a claim against his employer for the employer's negligence. It's a dangerous business. So if you've been injured and there's a possibility of showing negligence on the part of the railroad, that worker needs to hire a good FELA lawyer who can help understand the accident, get to the accident site, talk to the witnesses, get the information from the trains and from the video cameras that are all over the place to present the case to show the conditions or the negligence of a co-worker that led to your injuries. One example for a Long Island Railroad worker who slipped and fell on snowy, icy conditions. The railroad denied that there was anything wrong, but we forced them to give us the videotape in the yard, which is always on, and there, of course, we can see the snow and ice in the condition where the worker slipped and fell. That led to them saying, okay, we'll settle. If they don't settle and they want to play hardball, these are cases that can be brought in court. If you've had an accident, you need to follow the rules and regulations about reporting the injury. Get in touch with your union shop steward. Get in touch with an FELA attorney such as our firm. A lot of times people think, oh, it's all my own fault. And then you look into it further and you say, no, it wasn't. Management failed to provide you a safe place to work. They are on the string for responsibility. So our firm works on a contingency fee basis. We don't charge you expenses that we incur in investigating the case. Until we resolve the case, we follow the law as to what percentage our fee can be, and the rest, of course, is for the injured client.